Welcome to the Magna Carta of 1215 class by the Grumpy Old Vet. This is Lesson 3 of 28. This class will cover the second genealogical document that our founders used as a base for the founding documents that created the greatest nation ever on the face of the earth. I will give the context of the history surrounding this document, and because it is in Old English, after each slide, I will give commentary in plain English to make it more understandable. With that, let's move out. Welcome to the Magna Carta of 1215 class, brought to you by the Hillsdale Justice Project at Liberty Hall. Narrated by John Rutan. The reign of King John, events leading to the Magna Carta. King John of England, reigning from 1199 to 1216, is one of the most infamous monarchs in English history. His rule was marked by continuous conflict with his nobles, the church, and even his own family. Before he was compelled to sign the Magna Carta in 1215, John faced a series of struggles that shaped his legacy, particularly his disputes with Archbishop Stephen Langton, his controversial taxation policies, and his development of administrative structures such as the exchequer. Additionally, the role of the sheriff during his reign exemplifies the extension of royal power into local governance, a theme also reflected in the legendary tale of Robin Hood. Conflict with Stephen Langton. One of John's most notable conflicts was with the Catholic Church, particularly concerning the appointment of Stephen Langton as Archbishop of Canterbury. Following the death of Archbishop Hubert Walter in 1205, John sought to install his own candidate, but Pope Innocent III instead appointed Langton. John refused to recognize Langton, leading to a prolonged struggle with Rome. In response, the Pope placed England under an interdict in 1208. Suspending church services and sacraments throughout the kingdom. John retaliated by seizing church property and increasing financial burdens on the clergy. The dispute escalated until 1213, when John, facing the threat of a French invasion backed by the Pope, capitulated. He accepted Langton, surrendered England as a fief to the papacy, and agreed to pay an annual tribute, effectively making England a vassal state of Rome. Taxation and the financial burden on England. John's financial policies were deeply unpopular and contributed significantly to the widespread discontent that culminated in the Magna Carta. His father, Henry II, and brother, Richard the Lionheart, had established strong taxation systems, but John expanded them to oppressive levels. One of his most notorious taxes was scutage, a fee paid by barons to avoid military service. Unlike previous kings, who only levied scutage in times of war, John demanded it frequently and at increased rates. In addition to scutage, John employed harsh feudal dues, arbitrary fines, and trade restrictions to extract wealth from his subjects. His loss of Normandy to the French king Philip II in 1204 further strained his finances, prompting him to exploit feudal rights, such as inheritance fees and marriage levies, to replenish the royal treasury. These financial pressures fueled resentment among the barons, who saw their wealth drained without receiving protection or stability in return. The exchequer and royal administration. Despite his reputation as a tyrant, John played a significant role in strengthening England's bureaucratic and financial institutions. One of his key contributions was the development of the exchequer, an administrative body responsible for managing royal revenue. The exchequer had existed before John's reign, but he expanded its reach, making it a central institution for tax collection and financial oversight. It functioned as a treasury and audit office, ensuring that taxes were collected efficiently and recorded meticulously. The system involved detailed financial records, including the pipe rolls, which documented royal income and expenditures. The role of the sheriff. During John's reign, the sheriff was the most powerful local official in England, acting as the king's representative in the shires. The sheriff was responsible for enforcing royal law, collecting taxes, and maintaining order. In many ways, he was the embodiment of the king's authority at the local level, with the power to arrest, execute justice, and suppress dissent. Unlike later periods where the office of sheriff became more administrative, in John's time, Sheriffs wielded significant military and judicial power, often leading local forces and acting as the king's enforcers. The sheriff's authority was absolute within the shire, making him a feared figure, especially as John increasingly relied on them to extract taxes and punish rebellious nobles. Sheriffs often exploited their position for personal gain, exacerbating tensions between the crown and the nobility. This growing resentment toward corrupt sheriffs played a crucial role in the baronial rebellion that led to the Magna Carta, the legend of Robin Hood in political context. The legend of Robin Hood, though fictional, reflects the political realities of John's reign. According to the tale, Robin Hood was an outlaw who opposed the tyranny of the Sheriff of Nottingham, a corrupt royal official who extorted the people through excessive taxation and oppression. This mirrors the historical reality of John's administration, where sheriffs were seen as enforcers of the king's unjust policies. The story also highlights the broader struggle between the monarchy and the barons. In some versions of the legend, Robin Hood is portrayed as a supporter of King Richard the Lionheart, waiting for his return to reclaim the throne from John. This element aligns with the historical fact that many English nobles remained loyal to the memory of Richard and viewed John as an illegitimate and unworthy successor. The Robin Hood legend, therefore, serves as a symbolic representation of the resistance against John's rule, illustrating the widespread discontent that ultimately led to the Magna Carta. Conclusion: King John's reign was defined by conflict, financial exploitation, and administrative expansion. His disputes with the church, oppressive taxation policies, and reliance on powerful sheriffs created an environment of widespread discontent. The development of the exchequer and his bureaucratic reforms strengthened royal control, but also intensified opposition from the nobility. The legend of Robin Hood, while fictional, captures the political climate of John's England, where royal officials were seen as oppressive agents of an unpopular king. These tensions culminated in the baronial revolt of 1215, forcing John to sign the Magna Carta, a document that sought to limit royal power and establish the principle that even the king was subject to the law. King John of England ruled from 1199 to 1216, and he has gone down in history as one of the very worst of English kings, both for his character and his failures. He lost the Angevin Plantagenet lands in France, and so crippled England financially that the barons rebelled and forced him to sign the Magna Carta Charter of Liberties in 1215. The son of Henry II of England, 1154 to 1189, and Eleanor of Aquitaine, 1122 to 1204, John succeeded his elder brother Richard I of England, 1189 to 1199, as king. The celebrated Magna Carta that he was obliged to sign limited royal power and emphasized the primacy of the law overall, including the monarchy. Following his death while fleeing a French invasion force, King John was succeeded by his young son Henry III of England, 1216 to 1272. King John may not have been talentless, but he was certainly managing to make himself one of the most unpopular kings in English history. He lost the lands in Normandy. He invented income tax and taxed the people of England harshly. John also upset the church after his refusal to endorse Stephen Langton for the post of Archbishop of Canterbury. As Langton was the papal candidate, Pope Innocent III, 1198 to 1216, excommunicated John in November 1209 and ordered the closure of all churches. The idea that the king was chosen by God to rule, the so-called divine right of kings, was looking a little problematic for John to use as a basis for his authority now that the church had abandoned him. The Magna Carta signed and sealed by King John June 15, A.D. 1215 at Runnymede Meadow. John, by the grace of God, King of England, Lord of Ireland, Duke of Normandy and Aquitaine, and Count of Anjou. To the archbishops, bishops, abbots, earls, barons, justices, foresters, sheriffs, prevosts, serving men, and to all his bailiffs and faithful subjects, greeting. Know that we, by the will of God and for the safety of our soul, and of the souls of all our predecessors and our heirs, to the honor of God and for the exaltation of the Holy Church, and the bettering of our realm, by the counsel of our venerable fathers, Stephen Archbishop of Canterbury, Primate of all England and Cardinal of the Holy Roman Church, of Henry Archbishop of Dublin, of the Bishops William of London, Peter of Winchester, Jocelyn of Bath and Glastonbury, Hugo of Lincoln, Walter of Worcester, William of Coventry, and Benedict of Rochester, of Master Pandulph, subdeacon, and of the household of the Lord Pope, of Brother Aymeric, Master of the Knights of the Temple in England, and of the noblemen William Marshal, Earl of Pembroke, William Earl of Salisbury, William Earl of Warren, William Earl of Arundel, Alan de Galway, Constable of Scotland, Warren, son of Gerald, Peter, son of Herbert, Hubert de Burgh, Seneschal of Poitiers, Hugo de Neville, Matthew, son of Herbert, Thomas Bassett, Alan Bassett, Philip d'Aubigny, Robert de Ropelay, John Marshall, John, son of Hugo, and others of our faithful subjects. 1. First of all have granted to God, and for us and for our heirs forever, have confirmed by this our present charter, that the English Church shall be free and shall have its rights intact and its liberties uninfringed upon. And thus we will that it be observed. As is apparent from the fact that we, spontaneously and of our own free will, before discord broke out between ourselves and our barons, did grant and by our charter confirm, and did cause the Lord Pope Innocent III to confirm, freedom of elections, which is considered most important and most necessary to the Church of England, which charter both we ourselves shall observe, and we will that it be observed with good faith by our heirs forever. We have also granted to all free men of our realm, on the part of ourselves and our heirs forever, all the subjoined liberties, to have and to hold, to them and to their heirs, from us and from our heirs. 1. The English Church shall be free, with its rights and liberties protected. Freedom of elections in the Church is guaranteed and upheld. All free men and their heirs are granted specific liberties to hold forever. 2. If any one of our earls or barons, or of others holding from us in chief through military service, shall die, and if, at the time of his death, his heir be of full age and owe a relief, he shall have his inheritance by paying the old relief, the heir, namely, or the heirs of an earl, by paying £100 for the whole barony of an earl, the heir or heirs of a baron, by paying £100 for the whole barony, the heir or heirs of a knight, by paying 100 shillings at most for a whole knight's fee, and he who shall owe less shall give less, according to the ancient custom of fees. 3. But if the heir of any of the above persons shall be under age and in wardship, when he comes of age he shall have his inheritance without relief and without fine. 2. Heirs of full age inheriting estates through military service must pay the traditional relief, £100 for an earl's barony, £100 for a baron's barony, up to 100 shillings for a knight's fee, or less if custom allows. 3. Underage heirs in wardship inherit their estates upon reaching adulthood without paying relief or fines. 4. The administrator of the land of such heir who shall be under age shall take none but reasonable issues from the land of the heir, and reasonable customs and services, and this without destruction and waste of men or goods. And if we shall have committed the custody of any such land to the sheriff or to any other man who ought to be responsible to us for the issues of it, and he cause destruction or waste to what is in his charge, we will fine him, and the land shall be handed over to 2 lawful and discreet men of that fee who shall answer to us, or to him to whom we shall have referred them, regarding those issues. And if we shall have given or sold to anyone the custody of any such land, and he shall have caused destruction or waste to it, he shall lose that custody, and it shall be given to 2 lawful and discreet men of that fee, who likewise shall answer to us, as has been explained. 4. Administrators of underage heirs' lands must take only reasonable profits, customs, and services, avoiding destruction or waste. Sheriffs or custodians causing destruction or waste will be fined, and the land reassigned to 2 responsible and lawful men of the estate. If custody of the land is sold or granted, and the custodian causes waste, they will lose custody, which will then be reassigned to 2 lawful and discreet men. 5. The administrator, moreover, so long as he may have the custody of the land, shall keep in order, from the issues of that land, the houses, parks, warrens, lakes, mills, and other things pertaining to it. And he shall restore to the heir when he comes to full age,
his whole land stocked with plows and wainages, according as the time of the wainage requires, and the issues of the land will reasonably permit. 6. Heirs may marry without disparagement. So nevertheless, that before the marriage is contracted, it shall be announced to the relations by blood of the heir himself.
5. Administrators must maintain the estate, houses, parks, mills, etc., using its revenues and return it fully stocked when the heir comes of age. 6. Heirs may marry without harm to their status, but their blood relatives must be informed before the marriage is arranged.
7. A widow, after the death of her husband, shall straightway and without difficulty have her marriage portion and her inheritance, nor shall she give anything in return for her dowry, her marriage portion, or the inheritance which belonged to her, and which she and her husband held on the day of the death of that husband. And she may remain in the house of her husband after his death for 40 days, within which her dowry shall be paid over to her. 8. No widow shall be forced to marry when she prefers to live without a husband, so, however, that she gives security not to marry without our consent, if she hold from us, or the consent of the Lord from whom she holds, if she hold from another.
7. A widow shall immediately receive her marriage portion, inheritance, and dowry without payment or difficulty, and may stay in her husband's house for 40 days while her dowry is arranged. 8. No widow shall be forced to remarry, but must secure consent from her lord before marrying again if she holds land from them.
9. Neither we nor our bailiffs shall seize any revenue for any debt, so long as the chattels of the debtor suffice to pay the debt, nor shall the sponsors of that debtor be distrained so long as the chief debtor has enough to pay the debt. But if the chief debtor fail in paying the debt, not having the wherewithal to pay it, the sponsors shall answer for the debt, and if they shall wish, they may have the lands and revenues of the debtor until satisfaction shall have been given them for the debt previously paid for him, unless the chief debtor shall show that he is quit in that respect towards those same sponsors.
9. Neither the king nor his officials may seize revenue for debts if the debtor's property is sufficient to cover the amount. Sponsors of a debtor cannot be held accountable unless the debtor cannot pay. If sponsors pay the debt, they may take possession of the debtor's lands and revenues until they are repaid, unless the debtor proves the debt to them has been settled.
10. If anyone who has borrowed a sum of money from Jews dies before the debt has been repaid, his heir shall pay no interest on the debt for so long as he remains under age, irrespective of whom he holds his lands. If such a debt falls into the hands of the crown, it will take nothing except the principal sum specified in the bond. 11. If a man dies owing money to Jews, his wife may have her dower and pay nothing toward the debt from it. If he leaves children that are under age, their needs may also be provided for on a scale appropriate to the size of his holding of lands. The debt is to be paid out of the residue, reserving the service due to his feudal lords. Debts owed to persons other than Jews are to be dealt with similarly.
10. Heirs of a debtor who borrowed from Jews pay no interest on the debt while under age, and the crown may only claim the principal amount if it takes over the debt. 11. A widow keeps her dower without contributing to her late husband's debt, and underage children's needs are prioritized based on the estate's size. Debts to Jews or others are paid from the estate's remainder, after fulfilling obligations to feudal lords and family needs.
12. No scutage or aid may be levied in our kingdom without its general consent, unless it is for the ransom of our person, to make our eldest son a knight, and once to marry our eldest daughter. For these purposes only a reasonable aid may be levied. Aids from the City of London are to be treated similarly. 13. The City of London shall enjoy all its ancient liberties and free customs, both by land and by water. We also will and grant that all other cities, boroughs, towns, and ports shall enjoy all their liberties and free customs.
12. No scutage or aid can be imposed without general consent, except for the king's ransom, knighting of his eldest son, or marrying his eldest daughter, and these must be reasonable. 13. The City of London retains its ancient liberties and customs, and all other cities, towns, boroughs, and ports are guaranteed the same liberties and customs.
14. to obtain the general consent of the realm for the assessment of an aid, except in the 3 cases specified above, or a scutage, we will cause the archbishops, bishops, abbots, earls, and greater barons to be summoned individually by letter. To those who hold lands directly of us, we will cause a general summons to be issued, through the sheriffs and other officials, to come together on a fixed day, of which at least 40 days' notice shall be given, and at a fixed place. In all letters of summons, the cause of the summons will be stated. When a summons has been issued, the business appointed for the day shall go forward in accordance with the resolution of those present, even if not all those who were summoned have appeared.
14. General consent is required to assess aid or scutage, except in the 3 specified cases. Archbishops, bishops, abbots, earls, and greater barons will be summoned individually by letter. Landholders will receive a general summons via sheriffs and officials, with at least 40 days' notice of the date, place, and purpose. Decisions will proceed based on the resolution of those present, even if all summoned do not attend.
15. In future, we will allow no one to levy an aid from his free men, except to ransom his person to make his eldest son a knight, and once to marry his eldest daughter. For these purposes, only a reasonable aid may be levied. 16. No man shall be forced to perform more service for a knight's fee or other freeholding of land than is due from it. 17. Ordinary lawsuits shall not follow the royal court around, but shall be held in a fixed place.
15. Lords may only levy aid from free men for ransoming themselves, knighting their eldest son, or marrying their eldest daughter, and it must be reasonable. 16. No one will be required to provide more service for a knight's fee or free landholding than what is owed. 17. Ordinary lawsuits will be held at a fixed location, not follow the royal court.
18. Inquests of novel disseisin, mort d'ancestor, and darren presentment shall be taken only in their proper county court. We ourselves, or in our absence abroad, our Chief Justice, will send 2 justices to each county 4 times a year. And these justices, with 4 knights of the county elected by the county itself, shall hold the assizes in the county court, on the day, and in the place where the court meets. 19. If any assizes cannot be taken on the day of the county court, as many knights and freeholders shall afterwards remain behind, of those who have attended the court, as will suffice for the administration of justice, having regard to the volume of business to be done.
18. Certain legal cases, e.g., land disputes or inheritance issues, will only be heard in the local county court. The king or chief justice will send 2 justices to each county 4 times a year to oversee these cases, along with 4 locally elected knights. 19. If all cases cannot be resolved during the court session, enough knights and freeholders will stay behind to finish the remaining work.
20. For a trivial offense, a free man shall be fined only in proportion to the degree of his offense, and for a serious offense correspondingly, but not so heavily as to deprive him of his livelihood. In the same way, a merchant shall be spared his merchandise, and a husbandman the implements of his husbandry, if they fall upon the mercy of a royal court. None of these fines shall be imposed except by the assessment on oath of reputable men of the neighborhood. 21. Earls and barons shall be fined only by their equals and in proportion to the gravity of their offense. 22. A fine imposed upon the lay property of a clerk in holy orders shall be assessed upon the same principles, without reference to the value of his ecclesiastical benefice.
20. Fines for minor offenses will be fair and not too harsh, ensuring people can still make a living. Merchants and farmers will not lose their goods or tools if fined. Fines can only be set by trusted local people. 21. Earls and barons will be fined by people of the same rank, and the fine will match the seriousness of their offense. 22. Fines on a clerk's personal property will be based on the same principles as for others, without considering the value of their church position.
23. No town or person shall be forced to build bridges over rivers except those with an ancient obligation to do so. 24. No sheriff, constable, Coroners or other royal officials are to hold lawsuits that should be held by the royal justices. 25. Every county, hundred, wapentake, and tithing shall remain at its ancient rent without increase, except the royal domain manors.
23. No one will be forced to build bridges unless they have a long-standing obligation to do so. 24. Local officials like sheriffs and constables cannot handle cases that should be decided by royal judges. 25. Counties, districts, and communities will keep paying their traditional rents without increases, except for royal estate lands.
26. If at the death of a man who holds a lay fee of the crown, a sheriff or royal official produces royal letters patent of summons for a debt due to the crown, it shall be lawful for them to seize and list movable goods found in the lay fee of the dead man to the value of the debt, as assessed by worthy men. Nothing shall be removed until the whole debt is paid, when the residue shall be given over to the executors to carry out the dead man's will. If no debt is due to the crown, all the movable goods shall be regarded as the property of the dead man, except the reasonable shares of his wife and children. 27. If a free man dies intestate, his movable goods are to be distributed by his next of kin and friends under the supervision of the church. The rights of his debtors are to be preserved.
26. If someone who owes money to the crown dies, officials can seize enough of their belongings to cover the debt, as assessed by trusted individuals. After the debt is paid, the rest of the belongings go to the executors for the deceased's will. If no debt is owed, the goods belong to the deceased's family, with fair shares for the wife and children. 27. If a free man dies without a will, his belongings will be distributed by his family and friends under the church's supervision, ensuring any debts are still honored. 28. No constable or other royal official shall take corn or other movable goods from any man without immediate payment, unless the seller voluntarily offers postponement of this. 29. No constable may compel a knight to pay money for castle guard if the knight is willing to undertake the guard in person, or with reasonable excuse to supply some other fit man to do it. A knight taken or sent on military service shall be excused from castle guard for the period of this service. 30. No sheriff, royal official, or other person shall take horses or carts for transport from any free man without his consent. 31. Neither we nor any royal official will take wood for our castle, or for any other purpose, without the consent of the owner. 28. Royal officials cannot take crops or goods from anyone without paying immediately unless the owner agrees to delay payment. 29. Knights cannot be forced to pay for castle guard duty if they are willing to serve in person or send a suitable replacement. Knights on military duty are exempt from castle guard duties during their service. 30. Officials cannot take horses or carts from free men for transport without their permission. 31. Neither the crown nor royal officials can take wood for castles or other uses without the owner's consent.
32. We will not keep the lands of people convicted of felony in our hand for longer than a year and a day, after which they shall be returned to the lords of the fees concerned. 33. All fish weirs shall be removed from the Thames, the Medway, and throughout the whole of England, except on the sea-coast. 34. The writ called precipice shall not in future be issued to anyone in respect of any holding of land, if a free man could thereby be deprived of the right of trial in his own lord's court. 35. There shall be standard measures of wine, ale, and corn, the London quarter, throughout the kingdom. There shall also be a standard width of dyed cloth, russet, and habergeck, namely 2 ells within the selvages. Weights are to be standardized similarly.
32. Land seized from those convicted of a felony will only remain in royal control for 1 year and 1 day, after which they will be returned to the rightful lords of the estate. 33. All fish traps, weirs, will be removed from major rivers like the Thames and Medway, as well as across England, except along the coast. 34. A legal writ, precipice, cannot be used to bypass a free man's right to have land disputes resolved in his lord's court. 35. Standardized measures for wine, ale, and grain, as well as uniform widths for cloth and standardized weights, will be enforced across the kingdom.
36. In future nothing shall be paid or accepted for the issue of a writ of inquisition of life or limbs. It shall be given gratis and not refused. 37. If a man holds land of the crown by fee farm, socage, or burgage, and also holds land of someone else for knight service, we will not have guardianship of his heir, nor of the land that belongs to the other person's fee, by virtue of the fee farm, socage, or burgage, unless the fee farm owes knight service. We will not have the guardianship of a man's heir, or of land that he holds of someone else, by reason of any small property that he may hold of the crown for a service of knives, arrows, or the like. 38. In future, no official shall place a man on trial upon his own unsupported statement, without producing credible witnesses to the truth of it.
36. Writs of inquiry concerning life or injury will be issued free of charge and cannot be denied. 37. If a man holds land from both the crown, through certain tenures like fee farm or burgage, and another lord, through knight service, the crown will not claim guardianship of the heir or land related to the other lord's estate, unless the crown's land requires knight's service. 38. A man cannot be put on trial based solely on the accusation of an official. Credible witnesses must support the claim.
39. No free man shall be seized or imprisoned or stripped of his rights or possessions or outlawed or exiled or deprived of his standing in any other way, nor will we proceed with force against him or send others to do so, except by the lawful judgment of his equals or by the law of the land. 40. To no one will we sell, to no one deny or delay right or justice.
39. No free man will be arrested, imprisoned, stripped of property or rights, exiled, or harmed, except through lawful judgment by his peers or according to the law. 40. Justice will not be sold, denied, or delayed to anyone.
41. All merchants may enter or leave England unharmed and without fear, and may stay or travel within it by land or water, for purposes of trade, free from all illegal exactions in accordance with ancient and lawful customs. This, however, does not apply in time of war to merchants from a country that is at war with us. Any such merchants found in our country at the outbreak of war shall be detained without injury to their persons or property, until we or our Chief Justice have discovered how our own merchants are being treated in the country at war with us. If our own merchants are safe, they shall be safe too.
41. Merchants can travel and trade freely in England without harm or illegal fees, following lawful customs. In wartime, merchants from enemy nations may be detained but not harmed, until it's confirmed that English merchants are treated fairly in their country.
42. In future it shall be lawful for any man to leave and return to our kingdom unharmed and without fear, by land or water, preserving his allegiance to us, except in time of war, for some short period, for the common benefit of the realm. People that have been imprisoned or outlawed in accordance with the law of the land, people from a country that is at war with us, and merchants, who shall be dealt with as stated above, are excepted from this provision. 43. If a man holds lands of any escheat, such as the honour of Wallingford, Nottingham, Boulogne, Lancaster, or of other escheats in our hand that are baronies, at his death his heir shall give us only the relief and service that he would have made to the baron, had the barony been in the baron's hand. We will hold the escheat in the same manner as the baron held it.
42. Anyone can freely leave and return to England, except during war or if they are outlawed, imprisoned, or from an enemy country. 43. Heirs of land from royal estates, escheats, will owe the same duties to the crown as they would have to the original baron.
44. People who live outside the forest need not in future appear before the royal justices of the forest in answer to general summonses, unless they're actually involved in proceedings or are sureties for someone who has been seized for a forest offense. 45. We will appoint as justices, constables, sheriffs, or other officials, Only men that know the law of the realm and are minded to keep it well. 46. All barons who have founded abbeys and have charters of English kings or ancient tenure as evidence of this may have guardianship of them when there is no abbot, as is their due. 47. All forests that have been created in our reign shall at once be disafforested. River banks that have been enclosed in our reign shall be treated similarly.
44. Non-forest residents only need to attend forest court if directly involved or acting as sureties. 45. Officials like justices, sheriffs, and constables will only be appointed if they know and uphold the law. 46. Barons with proof of founding abbeys can oversee them when there's no abbot. 47. Forests and river banks enclosed during the current reign will be returned to their previous status.
48. All evil customs relating to forests and warrens, foresters, warreners, sheriffs, and their servants, or river banks and their wardens, are at once to be investigated in every county by 12 sworn knights of the county, and within 40 days of their inquiry, the evil customs are to be abolished completely and irrevocably. But we, or our Chief Justice, if we are not in England, are first to be informed. 49. We will at once return all hostages and charters delivered up to us by Englishmen as security for peace or for loyal service.
48. Harmful practices by forest officials, sheriffs, and river wardens will be investigated by 12 knights per county and abolished within 40 days, with the Crown informed first. 49. All hostages and charters given to secure peace or loyalty will be returned immediately.
50. We will remove completely from their offices the kinsmen of Gerard d'Aty, and in future they shall hold no offices in England. The people in question are Anglard de Cigogne, Peter, Guy, and Andrew de Chanceau. Guy de Cigogne, Geoffrey de Martigny and his brothers, Philip Mark and his brothers, with Geoffrey his nephew and all their followers. 51. As soon as peace is restored, we will remove from the kingdom all the foreign knights, bowmen, their attendants, and the mercenaries that have come to its harm, with horses and arms.
50. Gerard d'Aty's relatives and their followers will be removed from office and banned from holding positions in England. 51. Once peace is restored, all foreign knights, bowmen, attendants, and harmful mercenaries will be expelled from the kingdom with their horses and weapons.
52. To any man whom we have deprived or dispossessed of lands, castles, liberties, or rights, without the lawful judgment of his equals, we will at once restore these. In cases of dispute, the matter shall be resolved by the judgment of the 25 barons referred to below in the clause for securing the peace, subsection 61. In cases, however, where a man was deprived or dispossessed of something without the lawful judgment of his equals by our father King Henry, or our brother King Richard, and it remains in our hands or is held by others under our warranty, we shall have respite for the period commonly allowed to crusaders, unless a lawsuit had been begun, or an inquiry had been made at our order before we took the cross as a crusader. On our return from the crusade, or if we abandon it, we will at once render justice in full.
52. Lands, castles, liberties, or rights taken unlawfully will be immediately restored, with disputes resolved by a council of 25 barons. If the property was taken unlawfully by King Henry or King Richard and is now under royal control, it will be addressed after the crusade, unless legal action had already begun. Full justice will be provided upon the king's return, or if the crusade is abandoned.
53. We shall have similar respite in rendering justice in connection with forests that are to be disafforested, or to remain forests when these were first afforested by our father Henry or our brother Richard, with the guardianship of lands in another person's fee, when we have hitherto had this by virtue of a fee, held of us for knight service by a third party, and with abbeys founded in another person's fee, in which the lord of the fee claims to own a right. On our return from the crusade, or if we abandon it, we will at once do full justice to complaints about these matters. 54. No one shall be arrested or imprisoned on the appeal of a woman for the death of any person except her husband.
53. Justice on forests, land guardianships, and abbeys tied to previous claims by King Henry or King Richard will be addressed after the crusade or sooner if abandoned. 54. A woman may only appeal for someone's death if it involves her husband.
55. All fines that have been given to us unjustly and against the law of the land, and all fines that we have exacted unjustly, shall be entirely remitted, or the matter decided by a majority judgment of the 25 barons referred to below in the clause for securing the peace, subsection 61, together with Stephen, Archbishop of Canterbury, if he can be present, and such others as he wishes to bring with him. If the Archbishop cannot be present, proceedings shall continue without him, provided that if any of the 25 barons has been involved in a similar suit himself, his judgment shall be set aside, and someone else chosen and sworn in his place, as a substitute for the single occasion, by the rest of the 25.
55. Unjust fines imposed by the Crown will be cancelled or resolved by a majority decision of 25 barons and the Archbishop of Canterbury, if available. If a baron is personally involved in the case, a substitute will be chosen to ensure fairness.
56. If we have deprived or dispossessed any Welshman of lands, liberties, or anything else in England or in Wales, without the lawful judgment of their equals, these are at once to be returned to them. A dispute on this point shall be determined in the marches by the judgment of equals. English law shall apply to holdings of land in England, Welsh law to those in Wales, and the law of the marches to those in the marches. The Welsh shall treat us and ours in the same way.
56. Any lands or rights taken from Welshmen without proper judgment will be returned. Disputes will be resolved by local laws, English law in England, Welsh law in Wales, and March law in the Marches. The Welsh must treat the Crown and its subjects the same way.
57. In cases where a Welshman was deprived or dispossessed of anything, without the lawful judgment of his equals, by our father King Henry, or our brother King Richard, and it remains in our hands or is held by others under our warranty, we shall have respite for the period commonly allowed to crusaders, unless a lawsuit had been begun, or an inquiry had been made at our order, before we took the cross as a crusader. But on our return from the crusade, or if we abandon it, we will at once do full justice according to the laws of Wales and the said regions. 58. We will at once return the son of Llywelyn, all Welsh hostages, and the charters delivered to us as security for the peace.
57. If a Welshman was unfairly deprived of land or property by King Henry or King Richard, and it's still under our control, we will delay resolving the issue until after the crusade, unless legal action had already started. After returning from the crusade, we will resolve the matter according to Welsh law. 58. We will immediately return the son of Llywelyn, all Welsh hostages, and any peace-related charters we hold.
59. With regard to the return of the sisters and hostages of Alexander, King of Scotland, his liberties and his rights, we will treat him in the same way as our other barons of England, unless it appears from the charters that we hold from his father William, formerly King of Scotland, that he should be treated otherwise. This matter shall be resolved by the judgment of his equals in our court. 60. All these customs and liberties that we have granted shall be observed in our kingdom in so far as concerns our own relations with our subjects. Let all men of our kingdom, whether clergy or laymen, observe them similarly in their relations with their own men.
59. We will treat King Alexander of Scotland the same as our barons, unless his father's charters state otherwise. Any disputes will be resolved by the judgment of his equals in our court. 60. The customs and liberties we have granted will be upheld in our kingdom, and everyone, clergy or layman, must observe them in their dealings with others.
61. Since we have granted all these things for God, for the better ordering of our kingdom, and to allay the discord that has arisen between us and our barons, and since we desire that they shall be enjoyed in their entirety, with lasting strength forever, we give and grant to the barons the following security. The barons shall elect 25 of their number to keep, and cause to be observed with all their might, the peace and liberties granted and confirmed to them by this charter.
61. We granted these rights for God, to improve the kingdom, and to resolve conflicts with our barons, and we want them to last forever. Therefore, we give the barons this guarantee, The barons will choose 25 of their own to ensure the peace and rights granted by this charter are upheld.
If we, our Chief Justice, our officials, or any of our servants offend in any respect against any man, or transgress any of the articles of the peace or of this security, and the offense is made known to 4 of the said 25 barons, they shall come to us, or in our absence from the kingdom to the Chief Justice, to declare it and claim immediate redress. If we, or in our absence abroad the Chief Justice, make no redress within 40 days, reckoning from the day on which the offense was declared to us or to him, the 4 barons shall refer the matter to the rest of the 25 barons, who may distrain upon and assail us in every way possible, with the support of the whole community of the land, by seizing our castles, lands, possessions, or anything else, saving only our own person, and those of the Queen and our children, until they have secured such redress as they have determined upon. Having secured the redress, they may then resume their normal obedience to us.
If we or our officials break any rules or offend someone, and the issue is reported to 4 barons, they will bring it to us or the Chief Justice. If no action is taken within 40 days, the 4 barons can bring it to the other 21 barons. The barons, with the support of the people, can take our castles, lands, or possessions until the issue is resolved, but they cannot harm us, the Queen, or our children. Once fixed, they will return to their normal duties. Note: this is where the role of the sheriff changed in history. Prior to subsection 61, the sheriff was an agent of the state that worked under the pleasure of the state. In subsection 61, that role changed. The sheriff then had the authority of the state, and he worked under the pleasure of the people to protect them against the state.
Any man who so desires may take an oath to obey the commands of the 25 barons for the achievement of these ends, and to join with them in assailing us to the utmost of his power. We give public and free permission to take this oath to any man who so desires, and at no time will we prohibit any man from taking it. Indeed, we will compel any of our subjects who are unwilling to take it to swear it at our command. If one of the 25 barons dies or leaves the country, or is prevented in any other way from discharging his duties, the rest of them shall choose another baron in his place, at their discretion, who shall be duly sworn in as they were.
Anyone who wants to can swear an oath to support the 25 barons and help them hold us accountable. We will allow anyone to take this oath and will even force those who refuse to do so. If any of the 25 barons dies or can't fulfill their duties, the others will choose a replacement.
In the event of disagreement among the 25 barons on any matter referred to them for decision, the verdict of the majority present shall have the same validity as a unanimous verdict of the whole 25. Whether these were all present, or some of those summoned were unwilling or unable to appear, the 25 barons shall swear to obey all the above articles faithfully, and shall cause them to be obeyed by others to the best of their power.
If the 25 barons disagree on something, the majority decision will be final. They will all swear to uphold the rules and ensure others do the same.
We will not seek to procure from anyone, either by our own efforts or those of a third party, anything by which any part of these concessions or liberties might be revoked or diminished. Should such a thing be procured, it shall be null and void, and we will at no time make use of it, either ourselves or through a third party.
We won't try to take back or reduce any of these rights or freedoms, and if anyone tries, it will be void and we won't use it.
62. We have remitted and pardoned fully to all men any ill will, hurt, or grudges that have arisen between us and our subjects, whether clergy or laymen, since the beginning of the dispute. We have in addition remitted fully, and for our own part have also pardoned, to all clergy and laymen any offenses committed as a result of the said dispute between Easter in the 16th year of our reign, that is 1215, and the restoration of peace. In addition, we have caused letters patent to be made for the barons, bearing witness to this security and to the concessions set out above, over the seals of Stephen Archbishop of Canterbury, Henry Archbishop of Dublin, the other bishops named above, and Master Pandulph.
62. We have forgiven all past grievances and offenses between us and our subjects, both clergy and laymen, that occurred during the dispute, from Easter 1215 until peace was restored. We also issued official letters confirming this peace, signed by key church leaders.
63. It is accordingly our wish and command that the English Church shall be free, and that men in our kingdom shall have and keep all these liberties, rights, and concessions, well and peaceably in their fullness and entirety for them and their heirs, of us and our heirs in all things and all places forever. Both we and the barons have sworn that all this shall be observed in good faith and without deceit. Witness the above-mentioned people and many others, given by our hand in the meadow that is called Runnymede, between Windsor and Staines, on the 15th day of June, in the 17th year of our reign, that is 1215. The new regnal year began on the 28th of May.
63. We command that the English Church remain free, and that everyone in our kingdom retains all these rights and freedoms for themselves and their heirs forever. Both we and the barons have sworn to uphold these agreements honestly. This was given by our hand at Runnymede on June 15, 1215. Conclusions. In essence, the Magna Carta was an early document that helped lay the groundwork for constitutional law and the protection of individual rights, principles that were central to the formation of the U.S. Constitution and Bill of Rights. Both documents emphasize limiting government power and ensuring fairness for citizens through laws and rights. The 1100 Charter of Liberties established a process of government through laws, whereas the Magna Carta established the rule of law. That concludes the third class in this series, the Magna Carta of 1215. I hope you found this information helpful and entertaining. I will see you in Class 4, where we will go over the Petition of Right of 1628 in depth. Fall out!